Well, welcome everyone. We are so glad to have you all here. This is an exciting project that we've been working on through the UNM School of Law. It's called the Leafer Border Justice Initiative. We have received funding from a generous donor to start this project to try to make a difference in, working on border issues, particularly on asylum and other such things. So I am the Assistant Director of Career Services at the law school, and I've been lucky to be involved with this. We have a couple of faculty members that are heavily involved, April Land and Keish Suzuki, and a few adjunct faculty and also practicing attorneys, Becca Kitson and Jessica Miles, and I forget the other one off the top of my head, but we are working very hard on this project to create opportunities for volunteers to work on border issues, to create a pipeline for students to become qualified to learn about immigration law and get experiences and experiential learning opportunities so that when they graduate, they're ready to go out and practice. This project is very exciting. We're in the expansion phase, so we hope to create more connections out there with the community and explore new ways to address these issues. Part of it is part of the outreach are these excellent CLEs that we've been putting together, and we are very fortunate today to have Rebecca Kitson, who's going to present. She has her own very successful immigration law firm here in Albuquerque, and this she's well known by the people in this area. She presents often. She's an expert on crimmigration issues. She's taught the course here at UNM. She's on many boards and organizations on this. So we are very pleased to have her here. I do want to let you all know that we will be recording today's session. So you're free to turn your screen off if you would like. If you are interested in learning more about the project, please email me. My email address is in the chat, and I will also be monitoring chats. If you have questions along the way, you can go ahead and post them there. And if that's all right, Rebecca, I'll kind of interrupt you with questions and we can address those as we go along. And we do encourage participation. So, we're looking forward to this discussion. And with that, I will turn the time over to Rebecca.
All right, thank you, Patrick. Really excited to be part of the Leafer Border Initiative. It's a really fun project, and I'm really proud of the law school and everything that they've done to collapse the distance between our law school and the border, and to really serve the immigrant community, and as well as help bring up new immigration attorneys and other attorneys into the bar who have a background and experience in immigration as well. Okay, I'm going to share my screen. Also, I am joined by Simon Suzuki, who's with the Law Office of Public Defenders. Simon, you can say hi.
Oh, I'm frozen again. Can you hear me, everybody?
Yes, you can.
Okay.
Yes. Oops.
Hi.
My kids. There's my kids. Sorry. Okay. Oops. One sec here, and I'll get started. There we go. Yeah, so Simon's going to provide a little bit of support of criminal defense counsel along with us as we go through. As well, if anybody has questions, like Patrick said, I really encourage you to put them in the chat, so that we can involve some of that. My background is almost exclusively in immigration law, so the criminal defense bar perspective is always super important, especially in areas of crimmigration like this, where it's a true crossover. All right, so jumping right in. As far as talking about the duty to advise, why do we care? Why is it so important? Of course, it's the law and professional responsibility, but I think it's just important to remember that this is really profound stuff, especially for people who could potentially be facing removal. After the last few years of practicing immigration law under the current administration, it's been even more so. I think it's really brought it into relief for a lot of folks across the country, just immigration issues in general and the severe consequences that can occur. touching back really quickly on what is the U.S. Supreme Court as well as the New Mexico Supreme Court have both weighed in on the duty to advise, in particular for defense counsel. But I think it's important to recognize that, I know here, even today in this CLE, we have folks from the prosecution, we have people from the defense, and that the obligation to make sure that pleas are voluntary and that immigrant defendants are able to be fully informed as to the consequences of a guilty plea, there's shared responsibility across the board for that. And Padilla, in particular, says that there needs to be affirmative, competent advice regarding the immigration consequences of a guilty plea, and in absent such advice, that a non-citizen may raise a claim of ineffective assistance of counsel. So it's a little bit broader from the U.S. Supreme Court than what we have here in New Mexico, which under Paredes and since 2004, that there is specific advice regarding the impact a guilty plea would have on an immigrant defendant, what would have the consequences for that individual specifically. So under Paredes, it is much more specific in the sense that it's not only the broad duty to advise as to immigration consequences, but specific advice. And this is just a line specifically from Padilla that says that informed consideration of deportation consequences by both the prosecution and defense in order to reduce the likelihood of deportation and promote the interests of justice. So, again, it's talking about that broad and shared responsibility across the board for everyone to be informed. And I can say from my own personal experience, I joke all the time that my brain doesn't have any more space for any areas of law other than immigration. So I can understand the level of frustration sometimes with, especially with defense counsel, but everyone in regards to, feeling like you have to know immigration law or you have to know all the intimate details of it. I think that's where, of course, like the immigration bar really wants to be able to come in and provide that information and that advice for the criminal defense bar in particular, but everybody across the board. It has really been a moving target as of late. Even as of the last couple of weeks, we've had a whole series of memos and rule changes within the immigration court system. So it is very rapidly changing as far as how things are applied and the look on the ground. So, I've always said, really emphasize, reach out to those of us that practice in this area as well to be able to both learn and get the support that you need. This is a little bit about the rules within the state of New Mexico that require district courts in particular, but across the board, that the judge in any proceeding inquire as to whether or not the defendant has been informed as to the immigration consequences of a plea. So I believe it's next week, we have a second duty to advise CLE that will talk a little bit more about post-conviction relief and some of the ways that a conviction can be reopened and a plea vacated based on ineffective assistance of counsel. The judicial obligations can also be a basis for that. Right. So, immigration consequences. Under INA 236C, so anybody who's inadmissible or deportable for criminal grounds can be subject to mandatory detention. As I was discussing with Simon in preparation for the CLE, mandatory detention can actually be a much more severe consequence than almost anything else. Early on in my career, I had a client who pled guilty to negligent use of a deadly weapon, and that weapon was indeed a gun. But that statute in the state of New Mexico is actually a divisible statute, and so the government didn't have evidence of the fact that it was a firearms offense, which for a lawful permanent resident is not only a deportable offense, but is also one that subjects a respondent in immigration proceedings to mandatory detention. For my client, that meant that while he was defending his removal from the United States and fighting his case, he remained in detention for the better part of a year. It was almost 12 months that he was in detention for a petty misdemeanor. From the immigration side of things, he was housed at the El Paso Processing Center in El Paso, but because of some facility issues, he was moved to Sierra Blanca, which is a federal prison a short area away. So essentially he did, the better part of a year in federal prison for pleading to a petty misdemeanor. And so I just use that as an illustration because he wasn't fully aware of what his plea meant. These were the consequences for him. I'm glad to report that we were able to protect his green card. He is now a US citizen, but the cost was extraordinary to him and to his family. Obviously, removal from the United States is an immigration consequence. Loss of status, so loss of residency or loss of, student status, tourist visa status. I mean, if somebody's not able to come in and visit their family in the United States, that can be very severe, even if they don't necessarily live and work permanently in the United States. And disqualification for potential future benefits. If somebody's disqualified from becoming a United States citizen later, that also can be very severe consequence for them and their ability to petition for other family members or just to be able to fully participate in our democracy. And of course, federal enhancement under reentry. Some of the saddest cases that I see are people who, were removed and then, possibly had been here for a really incredibly long period of time. And then, if they're removed from the United States and they continue to attempt to re-enter, the enhancements there can be pretty severe. All right, so what is effective assistance? Affirmative misadvice, telling somebody, you'll be fine, you can't be deported from the United States, or I don't think this should have any consequence because it's a petty misdemeanor or something of that nature. I mean, you can't use logic and common sense when it comes to immigration. That's a sort of general piece of advice because sometimes things are really off from what we would normally consider in other areas of law. So anyone have a comment? They think affirmative misadvice?
I would say, and I apologize, Ms. Kitson, my camera froze, so I'm using my phone. I'm trying to reboot my computer. But I would say, yes, it's something that I definitely would always err on if I wasn't sure of something, to tell the client that we need to definitely look into this and figure out, what the consequences would be, so that way you're aware exactly of what you're facing.
Yeah, absolutely. So yes, affirmative misadvice, both the Padilla facts. I mean, in the U.S. Supreme Court case, I'm assuming that everybody has read it. If you haven't, you absolutely should. And it goes into detail of somebody who was facing, who had faced and pled guilty to state drug trafficking charges, and his attorney at the time told him that because he had been a resident for so long, he shouldn't be deportable. So affirmative misadvice was the facts in that case and clearly is ineffective assistance of counsel. Silence. What if you just don't know? What if you don't know that your client or individual is a foreign national? Patrick, do you have any?
That's my cue.
Totally calling on you.
So I worked at the public defender's office for a couple of years, and it was an excellent experience. So I have some experience in this area. But I had a client who was a Norwegian, and he had been in the United States since he was about 5 years old. So we negotiated a plea for him and all of this, but I didn't ask his immigration status. I had he didn't have an accent or anything. He talked about growing up in Santa Fe and all these things. I was like, oh, great. So, and it was a minor drug charge, but it was a drug charge. And, come to find out after the plea was entered, that he is not a citizen and that there were some consequences. So in that particular case, we did have to look into ineffective assistance and see what we could do to help this client. Now, fortunately for me, everyone, including the judge, we all were like, really? Wow. So, and I'm glad you mentioned the judicial responsibilities, because those are there too. And it was simply a case where none of us found out or were aware of his immigration status. And so we all kind of cooperated, including the judge, which was great as far as getting relief for the individual. But it's one of those things. You don't know what you don't know, and sometimes you just need to find out, because you never know what someone's status is, and you can't make any assumptions. And I will never, ever, ever forget that after that wonderful experience that I had.
Thank you, Patrick. Yeah, I think I'm a big fan and supporter of people sharing their mistakes. I feel like it just brings us all together, and everybody makes them. So it's a matter of, how to move through that. And how to, of course, prevent it in the future. And that, assumptions can really get in the way here. Obviously, foreign nationals come from many different countries, backgrounds, languages, all of those things. And so it very much is broad. And I know I have a lot of clients that were brought here as children, so-called dreamers. They essentially are as Americanized as you can possibly be, as well as people from, many, many backgrounds. So.
Rebecca, we do have a question from Anne.
Okay.
Thank you, Anne. Do you have a suggestion on how to ask that question without frightening the client? So I can go ahead if you
go ahead. No, by all means.
I was going to say, they're facing criminal charges. They're already pretty frightened. There's a lot of frightening things that we defense attorneys have to discuss. We have to discuss the consequences of conviction and all of that. So I think it's just one of those questions we ask: where are you born, or what's your citizenship status? I think it's that simple. And Simon, if you want to chime in, you were making a comment here, but you're on the front lines right now with defense. I don't know if his phone's back on, but.
Oh, yes, it is. Thank you, Mr. Martinez, or Mr. Lopez, I apologize. So we like to, because sometimes, especially with our clients at the Public Defender's Office, we represent people that are indigent, they're kind of at the margins of society. So there are a lot of things going on. And when there is an immigration issue, a natural response sort of, even though like Mr. Lopez is correct that there are questions that have to be asked, but sometimes situationally they are going to shut down. So if you ask them something, they'll freak out and they might give you incorrect information. So we like to kind of, make sure that they're comfortable and not catch them off guard. My experience, and it's just anecdotally, is that you ask them where they're born, they'll usually say, oh, I was born in Albuquerque, or I was born in Savannah, or I was born in Chihuahua. And then that's when I'll ask the question, well, what is your immigration status right now? And then we kind of go from there.
Yeah, and I think, a good thing to remember too is the additional question of, were your parents or are your parents United States citizens? Because it is a beautiful thing when you're able to discover that your client or that the defendant is indeed a United States citizen, because then it simply takes all of this off the plate. And there are people who acquire United States citizenship, it's by soil or blood. And so while the citizenship laws and acquisition of citizenship can be complex and they've changed throughout time, you can at least start the conversation in that way and reach out for help. So while both of the courts do speak to the duty to provide the specific immigration consequences of a plea, I would say that Paredes is incredibly specific about that. So we're talking about, disqualification for relief and all of that. So in general, I think one of the most important things to remember is just, telling somebody that it could result in their deportation or it could have an issue with their immigration status is not enough. That it really needs to be more individualized advice from their immigration consequences. So diving down a little bit deeper here with what the duties are at each step of the way. Initially, there's a duty to, of course, inquire about immigration status, just like we were just discussing. And, like Simon was saying, sometimes clients may be reluctant to discuss it. That is part of the art of practicing law, is trying to get that information out of your client and making them feel safe enough that they're able to do so. Also, I would add getting proper interpretation, proper and competent interpretation. I'm not assuming that somebody speaks English, and not even necessarily taking them at their word when they say that they can. Because I know I've really struggled with individuals that are like, no, I'm fine. And you're like, you're not getting me, you know? So go with your gut there. It's way better to really access good translation services if that's what you need in order to be able to get that information out of somebody and get for somebody to be able to feel comfortable in sharing those intimate details with you. Also, this is, digging down to some of the specifics that an initial interview would need to include, entry to the US, time and status, pending applications. And again, this is the type of information that's really helpful when it comes to doing that specific type of analysis. For immigration attorneys, it's really difficult for us to provide a quick and dirty assessment of any type of case because of the complexity of immigration law, and the position and the stance of the individual is really going to inform how we have to give our advice. So the more information, the better. And we typically do need immigration history, so entries and exits, as well as current status, if they've been previously removed and all of that, as well as looking for potential relief. Because again, if you're looking for the specific immigration consequences of a plea, it's not only looking backwards or looking at the loss of status right now, it's also looking prospectively and how that can impact somebody's decisions and opportunities moving forward into the future. So at plea and sentencing, obviously there's, this is where the rubber hits the road. And so there are very specific duties, to advise consequences of the plea and sentencing arrangements, also sentencing alternatives if there are alternatives available. Remember that incarceration may be preferable under some circumstances, depending on the ground of inadmissibility or deportability that you're looking at. Being incarcerated for a period of time and avoiding a larger suspended sentence actually can be preferable. So I know that it runs contrary to, again, general thought and logic and normal common sense, but there are times where, accepting incarceration may actually be a good thing for a client, depending.
If I can chime in there, Rebecca. So I experienced this, after this wonderful experience that I had. It was early on in my time in the public defender's office. But after that, I had situations where, you might consider pleading to a felony rather than a misdemeanor if it doesn't have the immigration consequences, or pleading to a different charge. There's a lot of different things that you can look at and that the DAs can be amenable to, especially if you're willing to plead to a felony, right? I mean, we try to avoid that at all costs. But sometimes for this individual, the consequences could be preferable, right? And the immigration situation just adds a unique layer there that makes things quite interesting. And the DAs tend to work with you and be amenable to a different charge or a different plea or things like that, so long as the facts actually fit. But there's room in the negotiation area, and I found myself doing some creative thinking here in trying to avoid some of these consequences after my initial step into the immigration world.
And you're still here, Patrick. Good.
I survived, yes.
So beware of suspended sentences. That kind of goes exactly to the same thing. There's times where it's a lot of times, not always, in some sections of the law where it's the imposition of the sentence. It's not, so suspension means nothing. It really depends on the area of law that you're talking about. Just like you were saying, Patrick, alternative safe haven pleas. There are sometimes the ability for the prosecution to get the piece that they need to get either a guilty plea or, some type of consequence for somebody's actions, while at the same time avoiding very drastic and draconian, intense types of consequences on the immigration side that just make it impossible for a person to accept. So working divisible statutes, there's times where somebody could still play to the same statute, but a different section. Again, as you're saying, if the facts allow for that, that may allow for some creativity there. Pre-prosecution diversion programs, if they don't meet the definition of conviction under immigration law, can be incredibly helpful. I know that with especially within misdemeanors, domestic violence cases, we see that a lot with pre-prosecution diversion, early intervention programs, which hopefully can have a good impact on families and that are struggling with that as well. Simon, have you had that experience?
Well, yes, I'll just say that I love pre-prosecution. In Metro, we call them PADs, pre-adjudication diversion agreements. Mm-hmm. And they're great because a lot of times, especially with like domestic violence cases or the petty misdemeanors that are officer prosecuted, they're often crimes of poverty or kind of like these family disputes that unfortunately sort of, burst out into other things where, the named victim or the officer, they see that, prosecution, a conviction or a plea isn't necessarily right for this client. So allowing the client kind of a second chance to show that they're, going to, stay in compliance with the court's orders, not pick up any new charges. And then the case would get dismissed and then it's not a conviction on their record. Sometimes there are some requirements, they might have to go to counseling, do some community service, maybe some treatment for drug and alcohol abuse. And sometimes it can feel pretty, like probation. And as long as you explain that to them, that it's going to feel like they're on probation, but most importantly, they will not have a conviction on their record, that the case will be dismissed and it will be truly dismissed.
I mean, I think it's good to remember too, just in advising foreign clients that while it won't be on, the conviction won't be on their record, that the charge and the circumstances of the case still will be. Nothing ever truly goes away for immigration purposes, unfortunately. And so depending on the person and, what their stance is, the facts of a case may still come up later on. Like I'll have clients will tell me, oh, well, it's all gone. It's all erased. It's, they told me it's gone. And I'm like, no, it's still there that you got arrested. And I'm like, here's your FBI report, and it's still listed on there and that we do still have to present it and explain it. So just a word of caution there, because people will literally take that and run with it and be like, I don't have to tell anyone about it ever again, and it's like, no, you still have to tell people. But it's something that without the conviction, it should have less consequence than a true conviction.
Rebecca, we have another question on chat. Yeah. Could you discuss the immigration consequences of expungement?
So I have in just like 2 more slides, I have a discussion about the definition of conviction for immigration purposes. And you can see that a lot of times, the way I describe it to my clients is a plea a plea is like a carrot in the ground with the green top on the top. If a plea is vacated due to constitutional infirmary, it's like pulling the entire carrot out of the ground. There's no carrot, you can start again, the person can be charged. Expungement in a lot of ways is like cutting the green top off. The carrot's still there. And so for immigration purposes, a lot of times expungement does not make the ultimate fact of the conviction go away. And once there's a conviction, there's always a conviction for immigration purposes unless it was constitutionally infirm. And so there's been additional and recent case law from the Board of Immigration Appeals on that has even said that sentence modifications, if they were for the purpose of immigration, will not ameliorate the consequences of the conviction in immigration proceedings. So it's pretty severe on the immigration side of things. So while I also explain to my clients a lot that I am envious sometimes of the criminal defense side of things, because they have so many tools available and different, different aspects and different tools that they can use to ameliorate the sting of convictions, where in immigration proceedings, and a conviction is a conviction if it meets the two-pronged definition that we'll go over here in just a moment.
We have a related question, which I think you can answer combined with it. The second judicial DA's office has a felony pre-prosecution diversion where the client has to submit an admission to the charges to participate in the program. Mm-hmm. How might this affect immigration consequences? And I had actually thought of this earlier when we were talking about this, but.
Yes, and I think I'm just going to flip through this because I think I have a duplicate slide here. And again, I'll get to that in just one slide. So just hold that thought one moment, and then we'll touch back on that. Just one more point on affirmative duties is respect your client's wishes. I all know that's very important. Sometimes I have to take a step back as well. Fighting spirit, rebellious nature that I have in wanting to really move forward with things. There's a couple of aspects of immigration law right now where it's more practical for us to comply with the request, even though it's contrary to law. And so there's times where the client's wishes and what's best for the clients, they define that. So there may be times, of course, where folks might want to accept removal from the United States. It just needs to be very clear in knowing if they're going to do that. And, of course, make sure that you make your extensive notes and protect yourself in that way if they're choosing to do something that could be later considered to be adverse to you. Okay, so here we go. This is the key thing, really. It's INA 101A48A, which defines conviction for immigration purposes as the two prongs necessary. That the finder of fact finds that the person finds the person guilty, or the person admits guilt, pleads no contest, or admits sufficient facts to support such a finding. Plus, there's some type of order of punishment, penalty, or restraint. Remembering, of course, that fines and probation can and do amount to punishment. So basically any type of punishment. However, the important thing here, especially for the previous question, is that there needs to be, the finder of fact needs to have that guilty information. So the admission needs to be to that individual. So if the admission is to the district attorney's office, that does not comply with this definition because the first prong is not met. Even if the person is required to comply with some type of a program or classes or fines or whatever, if the first prong is not met. On the, in a similar vein, and Simon and I discussed this a little bit as well, one thing that we continue to see is the use of conditional discharges. And in my immigration law class, I usually bring a standardized conditional discharge order and present it to my students. And then we debate about whether or not it would be a conviction. And almost inevitably, it's like 50-50 between whether or not, just after going through all this stuff, it's still confusing. Because of course it says without an adjudication of guilt. After the person admits guilt, that the judge proceeds without an adjudication. However, given the fact that the person admitted sufficient facts to support such a finding, under those circumstances, a conditional discharge is indeed a conviction for immigration purposes. So that's something that we still see as an issue within the state of New Mexico, and definitely in the past, older convictions and that sort of thing, where it is a powerful tool that can be used, and it's a good deal in some circumstances for a defendant, but it can be really fatal for immigration purposes, depending on what the charge is.
We have another question, which I think also relates.
Mm-hmm.
Is it better to stipulate to the facts when pleading and not laying any factual foundation on the record, or laying a factual foundation and being careful to avoid language which can invoke immigration consequences?
Classic answer for Jonathan. It depends. I know it's like the most frustrating answer ever. In some circumstances, the facts are important. So for example, if somebody is a lawful permanent resident and they're pleading to, possession of marijuana charge, the fact that it was under 30 grams and it was for personal use is something that would trigger an exception. There's a one-time exception for lawful permanent residents for a singular conviction for possession of marijuana under 30 grams for personal use. And Simon and I were discussing this as well, that in immigration proceedings, the way that the burden shifts is that if the government proves the fact of the conviction, the exception, the burden then shifts to the respondent to show that it meets the under 30 grams for personal use. So under those circumstances, it would be good to know that this is that type of conviction. This is a doobie conviction versus one that has to do with more severe consequences or some other type of like large quantity or within the trafficking type of context, which can be incredibly more severe for an individual. So in that circumstance, it might be a good thing. In other ways, laying a factual foundation, if it includes, facts, like for an aggravated felony, if somebody has committed fraud with, a loss in excess of $10,000, the $10,000 circumstance makes it an aggravated felony. So in that situation, that's where the creative plea construction comes in. There may be a way to, potentially compensate the victim or whatever, but if that information is clearly within the factual foundation, it seals the deal as far as the aggravated felony is concerned. That probably didn't help specifically, but call me. Okay, so this is a little bit of what we were just going through. In talking about conditional discharges, some diversion programs. Again, diversion programs work really differently. I am by no means an expert on all of the ones that are available out there. And in my practice, I see ones from states all over the country, as well as in the federal area as well. So they all function very differently. But my lens is always that two-prong approach. Was there the adjudication of guilt or the finding of guilt in some way with the trier of fact plus the punishment? If there is, it's a conviction, and then the consequences are triggered at that point if they exist. All right. So some of the things that are not considered to be a conviction, if something's handled in juvenile court, of course, it's a civil matter. If something is on direct appeal, it's still not finalized. It's not fully a conviction. Like I said, case vacated for legal constitutional error, or if it's not considered to be a crime. The direct appeal thing makes me think of, it really depends too, of course, on the individual, because if somebody's a lawful permanent resident and let's say they're being charged with drug trafficking, if it's up on direct appeal, that they can't be removed during that time if the conviction is not finalized. It's the government's burden in removal proceedings to prove the fact of the conviction. And if it's not completely finalized, it's not there yet. However, if somebody is undocumented and they've pled to drug trafficking and it's up on direct appeal, the person could still be deportable, removable from the United States because of the fact that they're undocumented. So those are the times where you'll see that ICE may still take somebody into custody and proceed with their removal. There's also a ground of inadmissibility that's called reason to believe that somebody's involved with drug trafficking, in which case, even if a conviction isn't final. So while cases that are on direct appeal might not be a final conviction for when a conviction is required, there are spaces and times, depending on the stance of the respondent in removal proceedings, of whether or not the person could still be removable anyway. Okay, so this is just a quick slide on potential safe haven pleas. And I have a couple of slides about the, inadmissibility, deportability, and, when to identify which one of those. Looking into whether or not an offense is categorically like a conviction involving a controlled substance. That would be a categorical type of ground of removability. If possible, the shifting of categories from one to the other. I think Simon and I were discussing this a little bit as well. But there's times where I will say like the classic safe haven plea in some ways is like disorderly conduct. I know that anybody who's worked with that before has has seen that because it's not a categorical crime. It's not a crime involving moral turpitude. However, you do have to be careful with things like those who hold DACA. You know, if you have a couple of misdemeanors, you can disqualify yourself regardless of the type. And then there's a ground of inadmissibility for when somebody has been sentenced, whether or not suspended, of 5 years of incarceration. And so that can build up to just because it's a cumulative type of thing. So there's a couple of grounds of inadmissibility or deportability that can kind of sneak up on you. And yes. Okay. In some cases, sealing a conviction may be helpful, and that kind of plays a little bit into the sort of discussion about expungement. Sealing a conviction, depending on the circumstances, if the burden is on the federal government, on ICE, in removal proceedings to prove the fact of a conviction and the conviction is sealed, that may prevent the completion of removal proceedings. It still may mean that there are significant consequences for a foreign national, but it really depends on the facts and circumstances of the case. I have seen that used before. Yeah, okay. So, moving on. Surprised I'm not getting bombarded with questions. I'm like, bring it on. So, the thing about the INA is that it's bifurcated by definition of entry. So this is part of the reason why immigration attorneys harp so much on, you know, what's the person's status? Have they held residency in the past? Did they come in with a visa? Did they come in without inspection? Like, what's their background? Because what grounds, what consequences apply to them is going to depend a lot on that definition of entry. Entry is inspected and admitted, means the lawful entry of an individual into the US after inspection and authorization by an immigration officer. An important thing to remember about this is that under case law, under the Board of Immigration Appeals, lawful admission can also include a wave through. So that's part of the reason why the facts become very important. Inspection and admission can be when somebody was brought over in their grandmother's arms and the officer said, go ahead. Grandma had a green card or whatever, made assumptions about the child. Happens all the time. Used to happen a lot more than it does now, but it's just important to remember that well over 2/3 of the undocumented population in the United States has been here for over 10 years, and most have been here for over 15. So a lot of this immigration history really appears from a previous time, and different administrations have really worked prosecutorial discretion or the border or different perspectives very differently. And so it's a little bit of a history lesson every single time. When somebody gives me their immigration history and they say this happened in 1991, I'm going to look at it in a very different lens than you know, if they said it was 2004. You know, the Real ID Act, all of the successive legislation, the different perspectives of, yes. So, 1 second. So part of the reason why it's so important to look at, you know, the definition of entry and which grounds apply is because it's really, really important to know the specific consequences, as we said at the beginning. And that applies to the form of relief as well. With people who are present in the United States, either with or without status, they have both the status that they're currently in, obviously the fear of being removed from the United States, but also the hope for the future and what types of status they could potentially apply for. So all of that is included within the immigration consequences realm. And in order to be able to understand that, you really have to see both which apply, and then also know in the future what type of relief that somebody could apply for. This is just my laundry lists here. I will make sure that my PowerPoint makes it around to the participants as well. There are both criminal and non-criminal grounds within admissibility. And with deportability, we have both as well. For criminal grounds in general, for deportability for those who have already been admitted, those who have lawful permanent residency or what have you. In general, a conviction is required for the deportability under criminal grounds. For inadmissibility, a conviction is not necessarily required, admission to essential elements of a crime. But in general, they, if a conviction occurs, there's no question there.
And a question from Simon.
Mm-hmm.
Would we need to follow up on how many times they've left and returned? Is that something we would have to know?
Yes, I think that's the sort of whole immigration, travel, and history is so essential, because if somebody had been coming in with a tourist visa many times, but their last entry was without inspection, they're going to be inadmissible to the United States, even though they were previously admitted. So that all of that really makes a difference. Plus, there's additional immigration consequences for overstays or multiple entries to the United States. If somebody's previously been removed from the US, obviously there's a whole slew of consequences for them there as well. This is just a quick general list of lawful permanent residents and some of the relief. The reason that I included some of this where it says discretionary grant, this also goes back to Jonathan's question about laying, the factual foundation. A lot of immigration relief, even if somebody's removable, for example, LPR, cancellation of removal. If somebody has their green card, they're an LPR, and let's say they're charged with, we'll use the fraud aggravated felony. They're charged with fraud. Somebody, the agreement is made, there's no part of loss of greater than $10,000 that's included in anything. Fraud is still a crime involving moral turpitude. So although you can dodge the aggravated felony, the person might still be removable if they have a previous crime involving moral turpitude in their past, even if it's shoplifting. Because with 2, you're removable. 2 CIMTs committed at any time after admission, you're removable from the United States. So at that point, the most common relief would be LPR, cancellation of removal. The creative lawyering, if you made it so that the person, you avoided the aggravated felony, which would mean that the person was practically precluded from almost all of these forms of relief on this list. I mean, aggravated felonies, most everybody is aware, is kind of the worst of the worst and have the most severe consequences. But with the 2 crimes involving moral turpitude, if the person meets the other requirements for LPR, cancellation of removal, has sufficient amount of time and sufficient status as an LPR in order to qualify, they have to show a positive balance of the equities, and it's a discretionary grant. So, again, that whatever's in the record is going to come out in immigration proceedings. And so, that's where the facts of the case really can come into play when it comes to a lot of the discretionary relief that we have. Can't change what people have done. We can't necessarily, warp things in any particular way, but there are ways to present the facts in the best way possible for a defendant.
We have a suggested clarification from April. Thank you. Would it be helpful to clarify the difference between admissible, removable, and deportable?
Right.
I'm not sure I know what those mean. So yeah, I think it's a good idea.
Absolutely. And so the definition of entry, if somebody has been inspected and admitted to the United States, then they would fall under the grounds of deportability versus the grounds of inadmissibility. Removable in general it's the overall term for removal proceedings, which are the immigration court proceedings that physically remove somebody from the United States or legally do so. So we have the grounds of inadmissibility and deportability. Prior to IRA in 1996, the terms were exclusion and deportation. And with the restructuring of immigration laws, we now have this definition of entry, and inadmissible and deportable are our 2 definitions. The way that the law shifted in 1996, it changed. It used to be the physical presence of somebody being either excluded or deported would be, are you physically in the United States or are you physically outside of the United States? With this definition of entry, somebody can essentially be on the porch if you consider the house to be admitted, and not admitted outside, you are in this kind of gray area where even if you're present in the United States for physically present for a long period of time, you're still facing knocking at that door and entry to the United States. So you're subject to the grounds of inadmissibility. The people who are in the house are subject to the grounds of deportability. Hopefully that helps. It is messy, not gonna lie. So one little quick list here as well. So these are some of the relief options that that we see for people who are not lawful permanent residents, and generally undocumented folks as well. It's even more, discretion plays even more of a role within people who are facing inadmissibility than people who are facing deportability. And again, discretion really comes down to, if somebody has, for example, multiple misdemeanors on their record, it might not preclude them from relief, but it could definitely make them unlikely to get a positive exercise of discretion in their case. So while this layer of complexity can be super challenging for a criminal defense counsel in particular, and for anybody who's working with foreign nationals in the criminal system, I think that the kind of layers that you're looking at here is, I kind of think of it in the different steps of doing an analysis. And when I've done analysis and expert support for the criminal bar, it generally what I look at is, what's the person's background, what is their immigration history, what is their prior criminal history, lay that all out, look at whether or not the person would be subject to removability. Could they possibly end up in front of an immigration judge? Could they lose their status? Could they be removed from the United States? And then from there, it would be that additional step of, what does this mean for future relief? Does this mean that they won't be able to become a United States citizen? Looking forward towards, that sometimes somebody's going to get convicted of something, and maybe they're already, maybe there's an ICE detainer, maybe there's something where it looks like there's going to be proceedings happening. We can safe assumption that a lot of times that is going to occur. Is there something that can be done to preserve relief for that person in the future? Or is there at least a way for them to be informed to consent to let that go? Because, they would prefer to return to their home country versus, facing whatever other criminal consequences that there are. So all of those things are important, and it is a multi-step process to really be able to analyze those consequences at all the different levels. And I know it's always a challenge. It always gives me pause, because I know that that's putting a lot of burden on a lot of people who feel that they don't have the tools to be able to do that. And in recognizing that, I can say that, reach out, get help, get support. Telling somebody to go talk to an immigration attorney does not comply with the requirements that the New Mexico Supreme Court has laid out. The requirement is with defense counsel to be able to provide that information. If you are with the public defenders, our very own Jesse Miles is part of the contract counsel with the Public Defender's Office to be able to provide that information. In the private bar, I think it's a matter of, if you represent foreign nationals, it's something you've got to be able to build into your practice. If that means being able to consult with somebody else, understand it in some type of way, and be able to explain that effectively to the clients. I am more than happy to work with people in that way as well. So, and this is kind of my statement for moving forward to the next session, is that, there are ways to ameliorate things once you've realized error. Mistakes do happen. I've done work with the disciplinary board in multiple different ways. I always like to, in the vein of, confession and, putting our mistakes out there. This is for you, Patrick. I self-reported myself early on in my career because of a mistake in immigration court that in order to reopen the case under matter of Losada for ineffective assistance of counsel, I did that. Our disciplinary board in the state of New Mexico is can be really supportive of attorneys who are accepting of their own mistakes. They know that mistakes happen. Pervasive mistakes or not accepting responsibility are different than honest mistakes that occur when you have a situation that you've never confronted before, like you, Patrick, and they're really an opportunity to grow. So there's, everyone can play a role there with the kind of ongoing duties after potentially, representation is formally ended. So let me see if anybody has any, follow-up questions or concerns. Do you want to share your stress? Any of the above?
Rebecca, did you want to advertise that next Friday we will be having a session with the disciplinary council and another groups to talk with them about what happens if you make a mistake, what the consequences are, what the law is. And I want to be very reassuring because when I asked the disciplinary council, our new disciplinary council, about who would be good to have on this and if she knew of anybody, and she said the people we deal with have made so many mistakes, I'm not sure that it's a great idea to recommend them. These are not the kind of mistakes that we are concerned about, but if you want to know how to deal with those kind of expected mistakes because of this complicated area of law, we invite you to join us again next Friday for her session with Kim Chavez-Cook of the Law Office of Public Defender.
Yes, and I think it's really good to get the information on and process and procedure on what to do after the fact and post-conviction relief and how we can continue to support immigrants after their criminal proceedings have concluded. And in discussing things with the disciplinary board too, it takes the kind of mystique off of that and makes it very concrete and accessible for people. Okay, this one. So I think we have a comment from Jonathan. If person is incarcerated, it seems like the state is indifferent to their status, but the feds are not so forgiving and put hold orders on the client. I don't know. I mean, maybe somebody else has some experience with that. I mean, my experience is in general, if somebody's facing federal charges, that it's much more connected within the federal system to immigration proceedings. And it's a little bit more of a do not pass go, do not collect $200. Immigration and federal criminal proceedings tend to be very, very closely united.
If I could just clarify that. So I'm talking about state level proceedings. So I'll have somebody that's in custody in a state level case, but it seems like the feds do these, I guess, background checks and then see obviously that their information doesn't match up, no social security card. And then I get a fed hold on just a state case.
Oh, are you talking about like an ICE detainer?
Exactly. What triggers that? Can you tell me anything about that?
There's still information sharing agreements between the state government and the federal government. The ICE has the ability to place a detainer. It is a request for state authorities to hold an individual. Of course, there's very clear rules on how long they can do that. They can only do so for 48 hours, excluding weekends and holidays. So if they don't pick them up within that period of time, if the person bonds out, the state authorities need to let them go. There's been litigation around that, and the state does not have to honor the federal request. They have to actively and affirmatively agree to do so. So it's not mandatory. It's a request. And it really depends on which facility that you're talking about, but there has been quite a bit of litigation around detainers. So, and from my understanding was that a lot of facilities were not honoring those detainers, but maybe that's not the case at this point.
And to just add on to that, just like a tip, our office kind of defaults to this. We were having some issues with ICE at the court, the local, like at Metro Court, and our office has done some activism on that. What I like to do is waive the client's appearance whenever possible. Even if there isn't immigration consequences, our clients are busy, they have busy lives. So to waive their appearance, and especially if it is a client that is potentially removable with immigration issues, if you could waive their appearance and kind of keep them out of the courthouse or away from law enforcement, that could really make a big difference too.
Okay, great. Well, thank you for coming.
Thank you, Becca, very much. Thank you all for coming, and thank you very much, Becca, for all of your heavy lifting, not just today for this, but all your work on the Leave for Border Justice Initiative. We really appreciate your contribution to our effort and to the immigrants in our state.
Okay, great.
Thank you, everyone, for attending. My email was in the chat, so if you would like copies of the PowerPoint, or if you have any follow-up, or if you're interested in finding out more, feel free to email me and I can follow up with you with any of those things. And I hope most of you will be with us next week for another exciting chapter of this. And thanks again, and we look forward to seeing you all soon.